For the record, I am the flesh and breathing man.
All right. Well, I'm glad you're breathing. So
When did you start smoking dope? When did you start smoking marijuana? When? Yeah. Dude, get your hair out of your face. Yeah. I'm better. I can see you now.
Mr. Jones, I'm going to tell you one. Mr. Jones, I'm going to tell you
I'm not allowed to object. I'm my own counsel now. I'm allowed to object, ain't I?
But listen, Ms. Pugh, don't speak over me. Ms. Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen, Ms. Pugh, stop talking over me. If you want to stop talking over me.
Because, Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it
understand?
an
Sir,
ORB.
your objections mean shit to me. So you keep saying I object, I object, I object. I don't care. I don't care what you're objecting to.
Discovery should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
Alright, this video has 6 of the wildest sovereign citizen court hearings I've ever covered. These people seriously try to outtalk the judge, deny the entire legal system, and it goes exactly how you'd expect. Every clip in here is a different kind of meltdown, and by the end, you'll probably lose some brain cells too. If you like crazy courtroom chaos like this and people getting humbled hard, make sure to like the video and subscribe so you don't miss the next one. Let's get into it.
For the record, I am the flesh and breathing man.
All right. Well, I'm glad you're breathing. So
For the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion. I need to know the jurisdiction this court is operating under.
so have a seat. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat.
If I don't come here, warrants will be placed, which I will be kidnapped and held hostage, and I do not want that.
Mr. Casanova, in the human flesh. I'm going to stop you right there. And I want you to hear me clearly. Hello. How's it going?
It'll be better.
All right. So my understanding, you want to represent yourself? All right. You're more than welcome to represent yourself. But here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules. So let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I'm the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me. There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
So we're back on the record in 2024 CR 2974, State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for.
That's right.
So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh, you don't understand? Okay, let's order a competency evaluation then. Seriously, at this point, I just feel like we need to update the law just for these sovereign citizens. I mean, could you guys even imagine if we had a law that actually prevented these guys from wasting everybody's time? Something like a mandatory reality check exam before they could even argue their own case. Maybe we should just give them an exam, like all pro se defendants should take this exam. And if they pass, they can represent themselves. If not, then they need a lawyer for sure. I mean, these people are literally out here thinking they can just say, I'm not subject to your laws, as if it's gonna stop a judge from handing down a ruling. Like, I've never seen that happen though. These people really need to realize that the Constitution's already got it covered, and no amount of paperwork they bring is gonna change the fact that laws apply to them too. These people really need to lay off the crayons.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness, you need surgery, and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right, Norma, get someone from manage to sign counsel here, please. All right, just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no, let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right, so let record of the court show that I, Hector Casanova
Just one
Jr.
second.
the accused
Just
in
one
the
stop.
Yes, sorry.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action.
Man, this guy is just digging himself a bigger hole with every word. Like, he literally can't even keep track of his own lies. The judge already laid it out for him, clear as day, what he's being accused of, and yet he's still sitting there acting like he has no idea what's going on. It's like this dude thinks the more he stalls, the more his little sovereign citizen script will work. Newsflash, buddy, it is not working. It's just embarrassing at this point. I mean, how do you come into a courtroom, get told what you're being charged with, and then act like the truth doesn't even matter. It just seems like he's putting on a whole performance here. And let's also not forget, lying in court is perjury, a very serious crime. So I don't know how the judge is going to go about that, but she laid it out clear, and he's lying right to her face, so it's not looking too good for this guy.
All right, and
Furthermore,
let me
let the
stop
record
you.
also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment. And the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they, civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from managed assigned counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mhm.
I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mhm.
Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under.
All right, I'm going
admiralty or military
to counsel,
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for managed assigned counsel, period. That's it. So have a seat, managed assigned counsel will come over. Do you understand? Yes or no?
I do not understand.
All right, do you understand what it means to take a seat?
I do understand.
All right, so take a seat. Thank you.
Usually I hate soft judges because I think they're totally ineffective. Like, a lot of judges handling sovereign citizens just don't do it right. But honestly, I don't think Judge Boyd is soft, by the way, but she's just got this calm, collected approach that works perfectly for this idiot, though. And I think this might be the best way to handle these idiots. I think yelling at them only makes them more and more annoying, but you can tell Judge Boyd is, like, very, very smart in this one. And she's processing every single answer very, very wisely. I mean, she's practically handling it like a pro. And this dude is getting outsmarted in every single aspect. And the best part about this whole thing, he has absolutely no idea. He thinks he's got it all figured out, but she's literally playing him like a fiddle here. It's honestly kind of hilarious watching this dude walk right into every single trap she sets without even realizing it. Let me know what you guys think. How do you think she's handling it so far? Let's dive back in.
We have talked.
Mhm.
I've informed him that I'm here, to help him in whatever he needs help with.
Mhm.
He's gonna consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay, all right, and so you'll be appointed as standby
Yes.
counsel then?
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing. So.
All right, we're going to go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes. All right, so Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right, who threatened or coerced you to come to court?
The county of Bear, Texas.
How
State.
so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date, and you can accept the state's offer, come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date, and then you'll sign it. Mr. Bonk will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome, and thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator, and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
When did you start smoking dope? When did you start smoking marijuana? When? Yeah. Dude, get your hair out of your face. Yeah. I'm better. I can see you now. I can pretty much paint the picture of your life for the next 5 years. Okay. You are like the poster child for Mr. Laid Back. Wow. You got me with your logic on that one. Come on up, Mr. Vick. Mr. Vick, are you going forward today without benefit of a court-appointed attorney? Where's your attorney then? Who's your attorney? Then you're doing it without one, right?
Yeah.
Do you want to do it without one, or you want to talk to one of ours?
I'll do it without one.
Okay. Dude, get your hair out of your face. Yeah. I'm better. I can see you now. All right. All right. I've got a ticket here, and the prosecutor says you're going to plead responsible to double parking, and we're going to dismiss a misdemeanor charge of reckless. Is that correct?
Yes.
That's the way you want to resolve this today?
Yeah, miss.
Okay. How old are you?
17.
All right. I understand you're almost done with school.
Yes, sir.
Then what's your plan?
I've been trying to get a job ever since I was 7.
Stop right there. Stop right there. Where have you been trying to get a job?
Trying to get a job at the service yard at Holiday Inn at the apartments.
Okay. Why do I have a ROA for double parking? And we've already got a ROA for it? Oh,
So everything.
it's confusing. No, it's not the way I'm used to saying it. I thought we had 2 tickets going. Okay. All right. Where else have you looked?
I looked at the baby shop in Logo,
Okay.
and I also looked at Walmart and Buffalo Wild Wings.
And nobody's hiring you?
Well, Walmart, I don't know, but I can't get a response from Buffalo Wild Wings, and I'm trying to go to the holidays.
Okay. Okay. All right. You got a driver's license?
No, sir.
Yeah, transportation's gonna be an issue then. All right. So what's your long-term plan? Done with high school, then what?
I'm trying to be an engineer.
So you're going to school somewhere.
Hopefully that's.
Where and when?
Well, I graduate this year and maybe I hope to go to college. Maybe by the time I'm 19.
Okay. What are you waiting for?
Nothing really.
Then why aren't you going to college now? As soon as you graduate?
I'm trying to finish school right now.
No, as soon as you graduate.
As soon as I graduate.
Yeah. Why aren't you planning on being in school somewhere in the fall?
I mean, I really didn't think about that, but.
When did you start smoking dope?
I can answer that. This dude has been smoking since he came out of the womb. Like, the doctor probably cut the umbilical cord and he hit the blunt right after. It doesn't take a genius to see it. I mean, this dude's eyes are half closed. He's moving at 2 frames per second and he's got the signature, "I have no clue where I am" face. This man is obviously a stoner and has no care in the world except for the Zaza. And listen, being chill is one thing, but when you're in a courtroom, looking like you just took a gravity bong rip is crazy. I mean, I wouldn't be surprised if this dude was high right now. Let me know what you guys think, because honestly, I feel like he might be right now. Let me know what you guys think.
When did you start smoking marijuana?
When?
Yeah.
2 years ago.
Okay. How often you hit it?
That often.
What's that mean?
Like barely.
What's that mean? Give me a frequency, brother. Once a month, once a week.
Speak.
Okay. All right. So on this file, you're not working now, so I'm not going to give you money. I'm not going to charge you fines and costs. I'm going to charge you community service hours. But I also have to give you a little lecture. Dude, I've been doing this a long time. All right? I can pretty much paint the picture of your life for the next 5 years. If you don't do something drastic. Okay? You are like the poster child for Mr. Laid Back. All right? If you're talking about going to school when you're 19, I can guarantee when you're 21, you'll still be talking about going back to school. Guaranteed. I mean, I would bet $100 of mine against one of yours that by then you could come back and we'd still have this conversation about your planning on it. Okay? If you were my nephew, I would put you in a car. I would drive you over to Canton on Ford Road. I would walk you into the recruiting office where you can talk to the Army, the Navy, the Coast Guard, Air Force. They're all in one building. And I would have you go door to door to door and find out what they could offer you if you sign up. Because that's what you need to do. You need to completely shake up your life to make something happen. Have you ever considered it? And I know you don't want to cut your hair, but it'll grow back. Have you ever considered it? Why not? Why? Because that's a valid reason. Wow, you got me with your logic on that one. Listen to me. How are you going to pay for engineering school?
Okay, well, if I get a job, I can pay for it.
No, you can't. You can't pay for an engineering degree working at Walmart. You can't. If you join the military, they'll send you to college. You know, every one of the branches of our armed forces have engineers. There are Army engineers, there are Navy engineers. That's a plan, dude. You don't have a plan.
Okay, well, the officer that got fired, well, I did have a plan. The officer that got fired, he should be the one getting it done.
Officer got you fired.
Yeah.
Okay, where were you working?
The USC.
Okay, and how did you mean a cop?
Yeah.
How did the cop get you fired?
He was a member at the USC, and when it happened, I guess he thought he had
You mean when this happened? Okay. All right. Okay. So I'll give you that. Okay. How's that change what we're talking? We're not talking about this case now. We're talking about your life. How's the cop getting you fired determine whether or not you can afford to go to engineering school?
Because I would have had a job to pay for.
The BYC isn't going to pay for 4 years of college, dude. What were you making? $15 an hour?
I mean, I was making about 14,000 a year, so I mean,
That ain't even gonna cover tuition.
This dude seriously just said he makes $14,000 a year and was gonna go to college if he didn't get fired from his little job. Like, I'm just not buying that at all. That's literally like saying I was totally gonna be a doctor, but then McDonald's let me go. Like, come on now. Like, I actually feel bad for this kid though, because if we're being real, it's honestly pretty obvious he doesn't have a male role model in his life to teach him how to act. I mean, judges don't have sympathy, but Judge Oakley here actually cares. I mean, you can just tell by the way he's talking to this kid. I really hope Judge Oakley actually sets him straight here, but honestly, I don't think he is. I mean, this kid seems like he's pretty set in his ways. And if I'm being honest, I don't think this kid is going to go to college, but even if he does, he's just going to drop out because honestly, I don't think this kid cares for authority, and that goes for like teachers, officers, judges. This dude just doesn't care about anything.
okay, well, I'm also adopted, so, you know, the state will pay for it.
Okay.
Okay.
I'll see you again. 30 hours community service, have it done by February 1st. Goodbye.
Mr. Jones, I'm going to tell you one.
Counsel.
Mr. Jones, I'm going to tell you
I'm not
what.
allowed to object. I'm my own counsel now. I'm allowed to object, ain't I? It's only 3 years.
When I'm talking, you do not talk over me. Do you understand that? Because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years. I don't need
Mr.
no help.
Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through voir dire. I've been through jury trials. I've done all this before. It's not
Did you go to
really
law
that
school?
No, I do not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
That's
you
3
won't.
years, man. It ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life, and you never know how good you might be at that.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. I had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm
That's
sorry.
Cool.
It's not cool. It's you're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
Yeah, gotta do what you gotta do, right? Even if it means taking an extra 3 years in prison when there's an option to get that reduced, makes total sense, right? This dude is already serving time for the aggravated robbery charge, so if he gets hit with that extra time after his jury trial, that's gonna be 13 years total. Like, what is this dude's plan here? He keeps saying 3 years, but he's looking at 13 years total. I mean, at this point, does he just want to rack up time for fun? Because it sure seems like it. I mean, there's literally no way around it. If the jury finds him guilty, that's what he's looking at. And based on this guy's demeanor here, he is definitely going to be found guilty. Let me know what you guys think. Let's dive back in.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what
Ms.
I
Martin
do.
does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now. I'm sorry?
That will be tested. We will see about that.
The other problem is obviously you have a right to remain silent. With you asking questions and you're making a huge mistake.
Add it to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions and picking the jury and everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay. There's the other problem. Because you are in custody, you have shackles on. Do you want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. They're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. Know a little bit more than most. Ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago, came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question. Are you aware of any? Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume, at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right.
This dude does not understand, like, not even a little bit. I swear, if he was facing 10 years, his reaction would probably be like, it's just 10 years. Like, bro, do you realize you only have one life to live? 3 years is actually a huge chunk of your life, and this guy's just acting like it's no big deal. Like, am I overreacting, or is 3 years a long time? Because honestly, if you go 3 years back, you really can't remember much. I mean, that's just me, though. It's honestly kind of scary to think that some people don't take the law seriously, especially when you've got people like this guy, who walk into gas stations, pull up with a weapon, and threaten everybody. Like, what makes you think that's okay? Like, is this guy mentally ill or something? Because this is not a normal thing to do. If you have free counsel, you might as well just take their advice on a few things. Let me know what you guys think in the comments. Let's dive back in.
There may be possible mitigating circumstances. Do you understand that?
Huh? No, nope, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3 years, man.
I'm sorry?
3 years. That's nothing.
Let me ask you. Let me tell you something. If when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
You try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental. It will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay. But you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. You understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Can I get a few minutes? I use the bathroom anyways.
Few minutes for what?
To use the bathroom, think about it, make sure this is what I want to do.
Take him to the bathroom.
This almost seems staged at this point. Like, how does this guy come up with that BS? There's actually no way he really wants to think about it now after all of this. He was so stuck on the fact that he was going to represent himself, and now, all of a sudden, he wants to think it over. Come on, I just feel like this dude is stalling at this point. I could be wrong though. I mean, what do you guys think about this whole thing here? Is he being sincere about thinking about it? Or is he just trying to buy some time? Because if I were the judge, I'd probably be thinking this dude is just trying to find a way out of this whole thing. Maybe even run away from the courthouse. I mean, this dude literally held up a gas station and got the 10 years. And now he's saying he doesn't care about 3 years. This dude really doesn't care about much, so... The red flags are raising right now. I really just don't know what this guy's thinking, though. But he is a loose cannon, so the cops got to be careful. Let's go ahead and dive back in.
Can I say something real quick, Your Honor? I didn't get that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to... I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The deputies and the transport officers are in charge of your security of this.
How am I supposed to use the bathroom in cuffs? How am I supposed to be able to wipe myself in cuffs?
All right.
Your officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes?
Yes, sir.
What's the issue with him?
I was never asked to remove the cuffs.
Yes, he was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right, let's get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself, obviously, is a logistics issue. Since you are incarcerated, the shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now, you can stand up at that table without your legs being seen because for the record, there's a skirt or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand that I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
Yes, sir.
I'm not gonna lie, I thought he was gonna say no to reading and writing. This dude is acting like a straight up idiot, so I mean, I wouldn't doubt it, but I mean, do you guys feel bad for him at all? Maybe this dude had a rough childhood or whatever, and that might have messed with his head, but honestly, there is no excuse to be acting like this when you're in a courtroom. I mean, regardless if you grew up bad or not, you should at least know not to act like this guy. And I know this guy isn't a typical sovereign citizen, but honestly, he might be worse. This dude is one of the rudest people we've ever covered on this channel. But not only that, he is not the smartest either. This is not the time to be playing games. You're literally in front of a judge, facing 3 years in prison. But let me know what you guys think. Does this guy deserve some sympathy? Or is he just digging his own grave at this point? And I feel like if he catches another charge in prison, he's just going to be like, oh, it's just another 5 years. But let's dive back in for the verdict here.
Are you on any type of medications or drugs?
No, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience, your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
All right. And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of.
All right. Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
I mean,
why don't we do this? Why don't we do this, Mr. Jones? Let's start. Let's allow Ms. Martin to represent you, and if something happens and you can change your mind later. It's easier to go that way than to go the other way. You can't have it both ways. What's that?
Can I use the bathroom, please? I really gotta go, sir. I just need to use the bathroom. I'd be a lot more focused and stuff. I really gotta use the bathroom.
All right, Rhodes, take him to the bathroom. I'm not going to go over this with you again.
That's
You have this
fine.
one last opportunity.
I understand, sir.
All right. Take him. Let's go off the record. All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Ms. Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Well, I'll represent myself then.
You want Ms. Martin
No,
to...
I don't want her near me, around me, or nothing. She can leave.
All right, sign the
She's good to
form
go.
in front of you.
What's the date?
Today's the 18th. All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel. Mr. Jones, you have, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
Oh, I don't need no
Mr.
help.
Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please.
The whole reason,
Mr. Jones, read.
Of representing myself was because I didn't trust the lady. That was
Okay,
the whole purpose of
she's
that.
not,
But she's still here and attached to my case. That's the
she's
whole
removing
purpose of
herself.
removing her was for that. Was for me to be able to represent myself.
You will be. Sign the form.
This
Read
form
it.
was already signed. You
All
already
right,
see my
read.
signature. You already
I'm sorry, I
asked me my
misspoke.
signature. You see my signature was on that sheet. You already see it was there. What are you talking about?
I seriously can't believe this guy is talking to a judge like this. He seriously does not care at all. Like, not even a little bit. The funniest part of the whole thing is that this dude is a scrawny little white guy trying to act all tough with the judge. Like, come on, man. Who are you fooling here? The judge isn't buying it, and honestly, neither are we. Let's just be real. This guy is 100% somebody's boyfriend in prison already. Maybe that's why he's so chill about staying longer. I think I just figured it out, guys. This dude has a whole relationship waiting for him back there. At this point, I'm not sure if he's delusional or just completely out of touch with reality. But it honestly makes sense. This dude is just a little guy trying to act tough, and he doesn't care if he gets another 3 years. I'm just saying, maybe he has a boyfriend. Who knows? You know, I'm not judging or anything, but I think I just figured it out. Let me know what you guys think. Let's dive back in.
Mr. Jones, read the form. You
Bro,
said you
I already
didn't read
signed it, man. It's cool. Go ahead.
Read the form. Are you able to read and write?
Sometimes. Depends on how many pictures are on.
You done?
I ain't read it. I
get
already
the form.
signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than that, are we ready?
Ms. Martin is standing by
Mr. Jones, I'm going to tell you Mr. Jones, I'm going to tell you
I'm not allowed to object. I'm my own counsel now. I'm allowed objecting, ain't I?
Then you say the word objection.
I did. I said I object.
What are you objecting to?
I'm objecting to Ms. Martin standing by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her was to represent myself because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution in order to help lay down and obtain a conviction. My removing of her wasn't based on...
Stop. Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry. All right, are we ready to bring the jury down?
Yes, Your Honor.
All right, bring them down.
But listen, Ms. Pugh, don't speak over me. Ms. Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on, listen. Ms. Pugh, stop talking over me. If you want to stop talking over me.
Where is the verified claim that is being placed against my trust?
You can go back with the bailiff. Go back with the bailiff. Get your own attorney or represent yourself if you don't like it. Good morning. Are you Janetta Pugh?
I am the beneficiary of that estate.
You're the what?
I'm the beneficiary of that estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand. Okay.
For the record, I recognize Ms. Pugh. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pugh's behalf.
All right, so Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents. considering that the first duty is to the state and will be considered conflict of interest, you know.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself? Or are you going to let Mr. Lewis represent you? Or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel defective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
No, it is not fine. You're making a complete fool of yourself right now, and we're all loving it. I mean, I'm really enjoying this judge's attitude, though. She's just sitting there patiently waiting for this girl to run out of steam from her nonsense sovereign citizen script. It's honestly just hilarious because these people always think they've unlocked some secret legal cheat code. But in reality, the law doesn't work like that, obviously. The courts have ruled over and over again that saying I don't consent doesn't magically make charges disappear. Like, that's not how jurisdiction works. I'm actually surprised, though, that this sovereign idiot can even read because, let's just be real, that's a very rare sighting in this community. But on a real note, I just need to know, how did she even get to this point? Like, what was her thought process here? She honestly seems like a sweet girl, but this is just straight up embarrassing. Like, she has manners and she's even saying your honor, but it's obvious that she's pretty lost right now and she's just grasping at straws. Let me know what you guys think about this girl because honestly, I just don't know how somebody could get down this much of a rabbit hole. Like, it's one thing to consider being a sovereign citizen and reading the script, but doing it is another thing. Like, I will just never understand it, but let's go ahead and dive back in because this one is not over yet.
So here's the thing, Miss Pugh. I appreciate your position, but listen, Miss Pugh, don't speak over me. Miss Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on, listen to me. Everything you have there is overruled. And here's one of the reasons why, is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
Or comply to your appointed
Go back.
agents.
You already said that, and that's overruled. Go back with the bailiff. Get your own attorney or represent yourself if you don't like it.
Yeah, that was embarrassing. But hold on, because this one is not over yet. This sovereign citizen actually comes back at a later date. And don't worry, I got you guys with that hearing too. I mean, at this point though, I feel like the judge deserves an award for patience because dealing with a sovereign citizen like this girl is basically like arguing with a brick wall. Except the brick wall thinks it knows constitutional law. So big props for the judge. I mean, the judge is just calmly trying to make sense of all this nonsense, and I'm here for it. She's being pretty snappy, but she's also pretty patient with her, which is fine, I guess, but Let me know what you guys think about the judge so far. Personally, I think she's handling this pretty well, but let's go ahead and dive into the next hearing and see if things get even more heated than this one. Let's dive in.
Perfect. So Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of the appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today if that's what you want to do. We'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you? Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I swear on everything, I was predicting her to say that right there. Believe it or not, guys. These sovereign citizens have literally infiltrated my brain, and I'm honestly starting to lose brain cells day by day breaking down these sovereign idiots on the daily. Like, they're just so insufferable and ignorant. It's honestly sad to watch, because a lot of these people probably have some mental health struggles. But seriously, it's not even just that. They're also just wasting public resources and time, which is a huge issue too. Courts and law enforcement have limited resources, and these people think they could just waste it all with their nonsense. But on another note, I'm also surprised this lady didn't bring her little script she had in the first clip. Maybe that time under the county jurisdiction in jail taught her to memorize her scripts. But yeah, if she decides to represent herself, she is probably going to be looking at 8 to 10 years here. So let's go ahead and dive back in to see if she actually wants to defend herself, because if she does, it is not going to look too good.
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself, by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I'm going to be able to do that.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine, after they listen to the evidence, if you're guilty or not. That doesn't have anything to do with if they find you guilty. you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, get ready like you would. Probably it's going to go straight onto a jury. And we'll just get it figured out that way. All right.
Because, Your Honor, I object.
What do you not understand? Sir,
RV.
your objections mean shit to me. So you keep saying, I object, I object, I object. I don't care. I don't care what you're objecting to. I'm going to hold you in contempt the next time you cut her off.
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying. I object to the
You
denying.
can't object. You can appeal. Brother, why'd you just waste 5 minutes of my life? You got a motion filed?
Yeah, oh, yes, absolutely. I actually have issues to discuss before I cross.
But the court reporter needs to pick you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threats, coercion, and I'm under duress. I'll cross.
You're under duress. How are you under duress?
Well, Your Honor, as stated in my motion, there's actually fraudulent word that since unsigned by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother. Wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. Trying to protect myself here.
That's fine. Just make sure you're talking to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yeah, I have a few in there that I've been repeatedly trying
Okay,
to
well,
be
which one do you
dismissed.
want to start with first?
Well, the recent one I filed, the motion to reject the swearing in and all that based off the fact that, like I said, I was sent a default motion that, I don't know how it even got sent out past the day, but it was never signed or anything. I was also defaulted out the fact that there was a citation that never even presented a court appearance.
Okay, hold
date
on.
and
You're
all
giving me
that
too
stuff.
many issues. You're talking about swearing in, you're talking about a default judgment. Just pick one issue. We're gonna deal with them one at a time. So what do you want to deal with first? You wanna
Well,
deal
my
with the
main motion.
default?
Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting set
that's the only
aside, so
civil
I
infraction.
have numerous, I have lots of stuff.
Hold on, that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking
Yes,
about
it was over
that
the-
charge.
Yeah, sure. It was over
Okay.
that.
So do you know why the default was entered? Did you miss a deadline? Did you
Well,
not?
I was notified, I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation, there was no date, and actually how fast it got issued would raises real concerns to me. And then once I received the default in
Okay,
the
hold
order.
on, hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I
of the
said
ticket.
it's in there, it's attached to my motions.
Okay, do you have a copy of
Yes,
the ticket?
I do.
Okay, then I'm gonna ask you to look at that copy of the ticket. Because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date, where it says appearance date on or before, there's nothing.
Okay,
They
but
didn't
it
give me no
says,
time frame.
it says contact court for appearance date. That
How
means the
long?
monkey's on your back to contact us.
I will also on the bottom of the tickets, it says, if you fail to contact court within the specified amount of time, there was no specified amount of time on here. I had no idea when I was supposed to contact court. I was dealing with trying to get my
Well, let
attorney.
me ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame
Mr.
to
Crucell,
contact the
Mr.
court.
Crucell, this is gonna go a lot easier on everybody if you just answer the question I asked. I'm gonna give you plenty of chance to give me any argument you wanna give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm gonna take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that, actually, when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting
Well, once
attorneys.
again, I'm going to draw your attention to the ticket.
This dude seriously cannot shut up, can he? Like, the judge just made such a solid point here, and instead of letting it sink in, this guy just keeps running his mouth. I don't get why these sovereign citizen types feel the need to argue with literally every single question the judge asks. It is not rocket science at all. The judge is just trying to figure out if this guy intentionally skipped his court date, or if he genuinely didn't know about it. But nope. Instead of answering like a normal person, he's out here acting like he's above it all. Like, does the sovereign citizen even know that he's digging his own grave here? Like, I can't tell if these people have no idea what's going on, or if they just genuinely think they're the smartest person in the room. I really can't tell sometimes, but let's dive back in.
My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I received, I'm sorry, I know I got the thing in the mail. When did I get this? This says that, I don't think it specifies the date.
Well, did you make a note when you received it?
This told me, this said I had I don't remember exactly what date I received this in the mail, but this was scheduled for March 8th.
Okay.
So that was even less than a
But what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and an warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no
Okay.
notice
Well,
of any
well,
sort of.
Once again,
appearance.
you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay.
There was no dates.
Okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crusoe brought this up when you were in front of the Honorable Judge Martin. She did set aside the default in the civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No.
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default's already been set aside.
Yes.
Brother, why'd you just waste 5 minutes of my life?
Since March 14th, Your Honor.
Which I object to that because they.
You object to your motion being
No, I
granted?
object to them setting aside my motion.
This dude literally got exactly what he asked for at his last hearing, and now he's acting like he has no idea what's going on. Judge Martin, his old judge, actually went out of his way to set aside this guy's default because he filed a motion asking for it to be set aside. Like, the court gave him exactly what this guy wanted. And now he's strolling in here all confused about his default date, as if it's someone else's fault. These sovereign citizen types kill me, man. They have no respect for the court, no respect for the process, or even the taxpayers who foot the bill for all this nonsense. Do they even realize how much time and money they waste by dragging these cases out with their made-up rules? What do you guys think about this guy so far? Should judges even entertain these type of people? Or should they just start handing out jail sentences whenever they bring up this BS script stuff? Let's get back to the video.
No. Wait. Listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Listen, okay, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly he's threatening me to issue
No.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
But the fact that I was threatened to come in and pay money or warrants.
How was that damage?
And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money, or I would have been, they'd have been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside, and Judge Green never said a word to me about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according, yeah, but that, especially now with the new Chevron overlay, that's just saying that she's just trying to set it aside, that there's no issues.
She didn't try to set it aside, she sat it aside.
But she can't. She can't just set my rights aside.
She's not setting your rights aside, she set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know, did she address the money?
No, she never did. No one did. It's written in my motion.
Sir, I'm gonna hold you in contempt the next time you cut her off.
There it is. That's the type of judge we need to take on these fools. Seriously though, looking back a few seconds into that clip, to be fair, it was kind of tough for the sovereign citizen here to know if the judge was talking to him. But come on, no matter how you slice it, this guy is just such a tool. His arguments are all over the place, and I really, really, really wish we could just see his clown face while he tries to make these ridiculous points. Even if he didn't know the judge was talking to him or not, this dude really just needs to shut his mouth or get a lawyer because his arguments are making completely no sense. Like, if somebody has any explanation for his stuff here, I would love to hear that because I really try to base stuff off the law and I really don't want to get too down the rabbit hole for these idiots. So at least the judge shut him up this time. Let's go ahead and dive back in to see if this idiot tries to interrupt again.
The first contempt, $100. The second contempt, a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the record?
Your Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay. I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right. So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At some point, trust me, your money will either get applied or returned. Next motion you want to talk about?
The dismissal based off the fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
Do you have, hold on, let me just cut to the chase. Do you have more than just the fact that you think you have a right to travel?
Yes, Your Honor. Actually,
that's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions you can appeal.
Absolutely.
Okay, hold on. I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying. I object to the denying.
You can't object. You can appeal.
Okay. Well, I'm just letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honestly, Your Honor, like I said, I even have lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about a lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get.
Okay, but that's got nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a stop?
Absolutely.
Then make the argument.
Yeah, Your Honor. So prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station and we in town, and we had, or in Sibley and Middle Belt, right near actually where I got pulled over, and we had discussed it and talked about it and went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I had specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then, this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him, I've already had this, I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. pulled me over, walked up, just started demanding ID and everything from me, and wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. And like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference of opinion within the department about whether or not what you were doing was legal or not.
Well, I
is that a fair
that.
summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop.
To be fair here, this guy's argument wasn't too bad compared to the usual sovereign citizen nonsense we see about jurisdiction and all that other BS. This guy is actually claiming that some officers told him it was okay to drive, but the one who gave him the ticket said he was in the wrong. Honestly, that's not the worst argument we've ever heard from these sovereign citizens. I mean, usually we see these sovereign citizens talk about jurisdiction, you know, flesh and blood man, and all that other BS. So it is kind of a breath of fresh air to finally get some common sense, a little bit of common sense at least. Usually we see about 2 brain cells working in some of these sovereign citizens' head, but today, you know, there might be 4 or 5, so, you know, that's a big plus, but, I mean, I could see how he might be a little confused, but I think he's definitely playing dumb here. Like, legally, the probable cause for the ticket was totally correct. You have to disclose your CPL if you're carrying, and on top of that, you need a valid driver's license too. Are you guys buying this guy's story? Because in my honest opinion, I don't believe a word this guy says. Let's go ahead and dive back in though.
So I'm going to let the prosecutor explain her position on probable cause. That's it. Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry v. Ohio in his newest motion.
Okay.
Because people submit that the investigatory stop exception in Terry v. Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the Fourth Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
All right.
Which I object to the.
Hold on. All right, so the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license. Okay, all right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not going to plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes or no? Mr.
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. Do you need me to clarify that ruling for your appeal reasons?
Yes, actually, because Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it
understand?
an
Sir,
ORV.
your objections mean shit to me, okay? I don't care what you're objecting to.
Objection, Judge. I don't like your response. I mean, I know it's the law and everything, but this super legit book I bought off Amazon says I can literally do whatever I want. It also says all I have to do is represent myself and scream objection anytime something goes wrong, and I'll be totally fine. Like, that's definitely what this guy read. Like, who needs actual legal knowledge when you've got a self-published guide on Amazon telling you everything you want to hear, right? These sovereign citizens just crack me up, man. I mean, if anything, I'm not gonna lie, I'm gonna have to blame the schools for this one. They should really be teaching us the laws. I mean, unless you watch videos online about the law and whatnot, you're really not gonna know much as an average person. So even though these people are very idiotic and delusional, there is a blame for it, and I'm gonna have to blame the schools in this one. Let me know if you guys agree with me on this, but I believe as kids, you know, we should grow up kind of reading the law and just at least understand basic laws like this stuff here. I know they teach it in driving school and whatnot, but I think it needs to be reinforced heavily. Let me know what you guys think. Let's dive back in.
I don't expect people to like every decision I make. That's why there's an appellate process. So you keep saying, I object, I object, I object. I don't care. All right. It's not helpful for today's process. My decision to deny your motion to dismiss based on lack of probable cause is because there was probable cause, because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to stop you. Do you have any other reasons why you think these matters should be dismissed today?
Yes, absolutely. First off, they're trying to label my private property as an ORV. It was not an ORV, and it's not even technically an ORV. If you look up the definition of ORV, it is not an ORV. If you look up the definition of automobile or vehicle or any of that sense, that's what it falls under. It does not fall under an ORV. They're just trying to label it as an ORV is what is happening.
Okay. That seems like that would be an issue for trial for you to testify, maybe me to see some photographs, maybe the officer to testify, and then I'll decide whether or not it meets the definitions of the statutes. Would you agree with me? Because that seems like a triable issue.
I suppose, yes.
Okay, well, this isn't the trial.
Well, I understand.
I don't think it's scheduled for trial. Right, this is just motion. All right. Any other issues that you want to hang your hat on as why it should be dismissed? It being these files.
Like I said, from the beginning, it was like the officer had already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's
witness to that as well.
Purcell, with respect, that's all your opinion. Obviously, the officer had a different opinion about all those things.
Well,
right?
The officer chose to retaliate against me is what happened, Your Honor. Which I have the evidence and I have witnesses going on.
Or he had a difference of opinion about whether or not you were driving an ORV.
Or just didn't understand the laws.
That could be too. That could be too. But guess who gets to make those decisions at trial?
Well, honestly, in the trial, I'd request a jury trial, which is guaranteed.
Well, you can't get a jury trial on the civil infraction, but you can certainly get a jury trial on the misdemeanors.
Absolutely.
Okay. Do you have anything else to be discussed today on motion day?
Well, yeah, as far as the disclosed CPL, like I said, I have, again, stating I have the body cams and I have my own recording.
So stop. That's going to be an issue at your formal hearing, whether or not you violated that civil infraction. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you. I'm going to hear from the officer that wrote the ticket. And then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial. No testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess best no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from this point.
File your appeal.
No, that's fine. I will.
File your appeal.
I'm going to. That's fine.
Okay. All right. Now, the 200, let's get back to the $280. We'll talk about a jury trial date. Are you going to represent yourself at a jury trial?
Yes, Your Honor.
Good luck. All right, now, Mr. Purcell, I'm going to strongly suggest that you get an attorney involved in this. And we've got court-appointed attorneys, so we'll be happy to talk to you from this standpoint. I'm not taking you to law school on the jury trial day. I'm going to assume and treat you accordingly that you know the rules of the game.
I understand, Your Honor.
You don't.
Oh,
You might say
comprehend.
that. You don't understand the rules. Okay? How many jury trials have you had?
None, but I have all the evidence.
How many jury trials have you had?
Your Honor, none, but I have all the evidence.
The evidence isn't the rules. There are a lot of procedural rules that will trip you up if you don't know what you're up against, and you don't. I'm going to suggest to you that even if you want to handle your evidence presentation yourself, you might want to get an attorney involved to help you with the procedural rules, because once again, I'm not going to take you to law school that day. I'm not going to subject the jury to that. It would be a waste of their time. You understand that? All right. Now, and I'm not trying to talk you out of a jury trial. Believe it or not, I'm trying to save you from yourself right now. If you want to have a bench trial, I will be much more lenient with you not knowing what you're doing procedurally, because then it's just our time. But when it's a jury in here, I'm going to run the most efficient jury trial I can. And that means I'm going to treat you like you're an experienced lawyer and know all the rules.
Okay.
All right.
All right.
So if you decide, number one, that you don't want a jury trial, you want to do a bench trial, let me know long in advance of that date so we can save it for somebody else. Or two, if you want the assistance of an attorney, I will give you the ability to talk to one of our court-appointed attorneys and see if they can assist you in the manner you want to be assisted.
Okay.
Understood?
Yes, Your Honor.
Any questions?
Nope.
Anything else? Have a nice day.
Discovery should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
I'm not trying.
I'm giving you your warning.
I would like to first have a jurisdiction hearing.
So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong.
Hello, Tariq Samar Tariq Day here.
Already, Judge Torsho Fleecer, Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
This is going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had another counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay. And at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
Spoiler alert, he showed up at 3 o'clock, even though he claimed he was coming at 3:30. This idiot here obviously knows the judge has jurisdiction over him, and this just proves it. But anyways, the judge is about to rip into this guy for lying to the court, which, by the way, is a big no-no. In the legal world, lying to the court is called contempt, and it can get you into some serious trouble. This dude is not only wasting everybody's time, but he is about to learn the hard way that court is not the place to play games. What do you guys think about this guy's strategy here? Honestly, I don't think it's too smart lying to the courts, but to each their own, I guess.
Sir, you indicated that you wish to represent yourself on this matter.
Yes.
All right, you understand at your arraignment, you were given the charges that were filed, have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding.
Fleeing and eluding third degree.
Third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
First, I wanted like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party Wall Street Towing and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest, cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
I really need to understand the thinking behind this guy. So he lies to the judge about COVID, then he just walks into court without a mask, demands the court has no jurisdiction, and says they need to dismiss the case because there's no injured party. Like, seriously, how many crayons did this guy eat before he came here? First off, the court definitely has jurisdiction. If you're in the courtroom, that's a big hint. And as for the whole no injured party thing, well, guess what? You don't need an injured party to go to court for certain cases, especially when you're in there for fleeing and eluding. This guy's out here acting like he's in a kindergarten debate club, but it's not working in his favor so far. Let's dive back in.
Finish.
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance, certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing.
This is a probable cause hearing.
So I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was.
You weren't able to do what?
Provide my exhibits.
To whom?
To the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not at this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
Is anybody else starting to feel bad for this guy? I mean, he's seriously getting cooked alive by this judge. Judge Simpson is done with these sovereign citizens. You can just tell. This guy's out here acting like he's at some kind of preliminary hearing, but the reality is, he's just way out of his league here. He has no clue what he's talking about, and it's honestly just painful to watch. Like, this dude thinks he needs evidence for this hearing, but I don't understand his thought process. Like, why doesn't he just get a lawyer? They offer free legal aid for a reason, but instead, this guy's out here trying to argue with the court like he's gonna win an Olympic gold medal in nonsense. What do you guys think about this guy's strategy? Let's dive back in.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not. They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been denied.
I wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about it.
Do you wish to have discovery?
Should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen.
Discovery.
Not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing.
What kind of jurisdiction here?
Personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
Do you guys think this idiot is playing stupid, or is he actually this dumb? This dude is really out here asking for a jurisdiction hearing. Like, what? A jurisdiction hearing is when you argue whether the court even has the authority to hear your case in the first place. It's something that typically happens at the very, very beginning. If you think the court doesn't have the power to deal with your case, then you would do it before the case even happens. This dude is really acting like that's going to change anything. Does this guy actually want a jurisdiction hearing, or did he just hear that on Reddit or something? Like, the court literally already has jurisdiction over him. If they didn't, he wouldn't have shown up at 3 p.m. He's in the courtroom, the case is set, and no, he can't just wave his hand and make it go away. I mean, who's giving this guy his legal advice? A magic 8-ball or something? Let me know what you guys think in the comments. Let's dive back in.
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threat and duress or coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter in regards to the name as well as the vessel that was used is again under it was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So with that.
All right, so here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong, because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the state of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step, and I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PC, to a preliminary examination.
Just for the record, I'll put it on the record that I object. But under threat, duress, or coercion, again.
Your objection is noted.
Right, and under threat and duress and coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or get it from the front?
Pardon?
Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed? Or I'm trying to figure out how to get the paperwork.
You can check out at the front desk.
Okay, thanks.
I know this guy's a sovereign citizen and clearly not working with the full deck here, but do you guys think Judge Simpson was too harsh on him? I mean, the judge was definitely being rude to this guy, but honestly, I don't think he was too harsh at all. In fact, I think it was pretty perfect. This guy came in acting like he was going to play a game here with Judge Simpson, but the judge hit him with a real dose of reality. Maybe even now this guy will finally come prepared and actually get a lawyer, because honestly, this whole sovereign citizen thing is getting way out of hand. These people are getting more and more popular these days because they latch onto conspiracy theories and fake legal loopholes, thinking they can escape consequences. Like, I really don't know what the cause of this is. Like, it's just getting really out of hand. And the main root of this is just avoiding responsibility. And that's why we're seeing more of them pop up, especially online where they get fed all kinds of crazy ideas. It's honestly wild to watch. Like, this is real life here. They think they could just bypass the system just by making up their own rules. And the court systems kind of allow them to, honestly. These people definitely need a reality check, and maybe if more judges gave them the same treatment as Judge Simpson did, we'd see fewer of these sovereign citizens in the first place. I think there needs to be a new set of rules for these kinds of people. People who just disrespect the courtroom and just show no authority at all. It's honestly wasting taxpayer money, and it's overall just rude, and it needs to end. Let me know what you guys thought about this hearing here. I love reading your guys' comments. Was Judge Simpson too harsh, or was he just giving the guy what he deserved? Let me know your thoughts in the comments. And if you enjoyed this type of content, make sure to like and subscribe. Thank you guys so much for watching. Take care.